Good afternoon, everybody. Thank you for joining us for another webinar in Conn Maciel Carey's OSHA webinar series. This is the penultimate webinar for the year, and I recognize a lot of names of folks who have joined us throughout the year, and I appreciate your interest in the program. These are a hard series to put on, a monthly program, but we get a lot of great feedback about it, and we're glad that you all could join us and that you're able to join us today. Today we are talking about OSHA's Fatality and Serious Injury Reporting Rule, or as I refer to it, OSHA's Reporting Rule, not to be confused with OSHA's Electronic Record Keeping Rule, which many in the trade press and many in our industry have taken to refer to as the Reporting Rule. And if for no other reason we're having this webinar today to settle once and for all which of these two rules ought to be called the Reporting Rule. And I guess I put it this way: if this is not the reporting rule, what are we going to call this? So I think we should all take to referring to the electronic record keeping rule as either the electronic record keeping rule, the injury data submission rule, or something like that, and leave this as the reporting rule. So that's my pet peeve aired today, but we will go on and talk about some of the details of this rule. I'm delighted to be joined today by my associate, Lindsay DeSalvo. I'll introduce us real quick, get into what we're going to cover, and then we'll dive right in. The first faceless voice you're hearing is Eric Conn. I'm one of the founding partners of Conn Maciel Carey and chair of the firm's national OSHA practice group. My practice focuses on all aspects of safety and health law, primarily, though, representing employers in inspections, investigations, and enforcement actions involving OSHA, state OSHA programs, and the handful of other federal and state agencies that get involved in safety and health. We also manage the full range of litigation involving safety and health matters, challenges to OSHA citations, including criminal investigations and prosecutions under the OSHA Act. I'll let Lindsay introduce herself, and we'll get started.
Good afternoon, everyone. As Eric said, my name is Lindsay DeSalvo, and I'm an associate here at Conn Maciel Carey. Unfortunately, we forgot to update the slide, but I am now Lindsay DeSalvo. And I am an associate in both practices. On the OSHA side, I represent employers during inspections. I advise and counsel employers when issues related to safety arise, or when they receive safety complaints or OSHA citations. And I also help develop and audit safety and health programs and set up that infrastructure for employers.
All right. So what are we going to cover today? Primarily, we're going to get into the real nitty-gritty of the reporting rule. What is required to be reported, by what deadlines, who is required to report, all that good stuff, and how has that changed over the years, and what's the current lay of the land there. Then we'll talk a little bit about what to expect after you do pick up the phone or use the online portal to report a fatality or serious injury to OSHA. Are we likely to see an inspection from OSHA? We're likely to get some other form of interface with the agency, or not hear anything at all. Then we'll get into some data and trends. What is it that's being reported? What is it that's most likely to trigger an on-site inspection and information like that? And then finally, because one of the common problems that we see is people applying the Fed rule in California, we'll just give a little bit of a distinction between what's going on in the two, across the two platforms. So we'll first start off with the injury and fatality reporting rule, a little bit of a history lesson about the rule. To start with, when the OSHA Act was first promulgated, there was already an obligation for employers to report fatalities and serious injuries to OSHA. Those circumstances have changed over the years, but the initial rule was that all fatalities, work-related fatalities, needed to be reported to OSHA, as well as what was known as catastrophes. And a catastrophe at the time in 1971 was defined by OSHA as an incident that resulted in the hospitalization of 5 or more employees. And that was from a single incident 5 or more employees spent an overnight stay in a hospital for medical treatment. In 1994, about 20 years later, the rule was updated to change. And one of the interesting things about the old rule was the ways that you report. You pick up the phone and call the nearest area office, or you use telegraph to report. So that's how, those were the modes of technology and communication back when this rule was first promulgated. And over the years, we've seen changes in how OSHA defines catastrophe, the timing to report, as well as the modes of reporting as technology has advanced. So kind of interesting to see in that history lesson as well. About 20 years later, in 1994, OSHA changed the reporting rule to still require the reporting of all work-related fatalities, but to lower the threshold for the number of employees involved in an incident to be characterized as a catastrophe that had to be reported to OSHA. So instead of 5 employees spending an overnight stay in the hospital for medical treatment, that number was lowered to 3 or more employees spending the night overnight at a hospital for medical treatment. So a catastrophe was now 3 workers from a single incident instead of 5. And I mean, you can imagine how rare it was under the first rule for 5 employees to go to the hospital in the same event. You're really, thinking about these explosion incidents, major collapses, releases, and things like that. And most of those circumstances, unfortunately, there is probably at least one fatality involved. So it was extremely rare that you would have the 5-person hospitalization. The rule changed to 3 hospitalizations, which did increase the frequency of hospitalizations having to be reported to OSHA, but still, for a single event to trigger a hospitalization, the scenario has to be pretty dire, a true catastrophe, and often in those circumstances there was a fatality involved, so it's being reported anyway. So it did not have a drastic impact on the number of incidents that were reported to OSHA. Instead of being in the, counting on all the digits of your hands and feet, maybe approaching the dozens of reportable hospitalizations. But the other major change, very significant change in 1994, was that instead of having 48 hours to report any of these events, you had only 8 hours to report any of these events, fatalities and hospitalizations. And OSHA also introduced a new way to report. Instead of only phoning your local area office or dealing with a telegraph, OSHA did introduce a new 24-hour hotline, a 1-800 number for reporting. Then finally in 2015, at the sort of approaching well into the second term of the Obama administration, we saw a new change in the rule, and the change was a very significant one. The circumstances for what was considered a catastrophe were basically thrown out, and we introduced a series of relatively, I don't want to say minor, but nothing in the manner of a catastrophe was required for a report to need to be made to OSHA. You still have to report all work-related fatalities, but instead of an event that sends multiple people to the hospital overnight, it became reportable to have a single employee hospitalized, and the definition of hospitalization was changed, and we'll get into that definition in just a moment. So instead of 5 employees from a single event, instead of 3 employees from a single event, it was 1 employee being hospitalized under a new definition of hospitalization became a reportable event. So instead of dealing with, a dozen or fewer major catastrophe events, and instead of dealing with perhaps a couple of dozen reportable hospitalization events, it became predicted that there would be hundreds and perhaps thousands of new events that became reportable. In fact, the original prediction was that it could be upwards of 100,000 events would now be reportable to OSHA that were not historically reportable. 3 of the other very significant changes in the rule were that amputations, work-related amputations, and again, we'll get into the nitty-gritty of what is a reportable amputation, became an automatic reporting event, even if it did not result in an inpatient hospitalization. And there are some other nuances to the amputation rule that has driven thousands of reports just on the concept of amputation. And then loss of an eye became a final new category of event that needed to be reported to OSHA. The idea there, I think there is, I think the concept was that OSHA originally considered a loss of an eye to be a form of amputation, but got enough feedback and notice and comment in the rulemaking period. They concluded that that might not be clear that that's considered a form of amputation, so it became its own special category. We're not seeing an awful lot of those being reported, but we are seeing a heck of a lot of hospitalizations of a single employee and amputations being reported. Another major change in the reporting rule that came in 2015 was the timing when events needed to be reported to OSHA. The rule that we had lived under the previous 20 years was that any event, any fatality or catastrophe had to be reported within 8 hours to OSHA. Now, only fatalities meet that 8-hour category. If a fatality event needs to be reported within 8 hours, and we're going to talk in detail about what is the trigger for that 8-hour period. When do you start counting that 8 hours to make your report? But the big change here was that instead of having to report your hospitalizations within 8 hours, you now had a longer period, 24 hours, to report the hospitalization, the amputations, and loss of an eye incidents. And the final change that came with the new reporting rule was, as technology continued to advance over the 40 years that we watched the reporting rule evolve, OSHA introduced a new web-based portal where instead of picking up the phone and calling either the local area office or the 24-hour hotline, which you can still do under the current rule, they also introduced a web-based portal where you could get online and type in your reporting event and hit submit rather than speak to somebody online. We'll talk a little bit in this program about our recommendations for which of those make the most sense to do and why. But that's what the new rule looked like. Talk a little bit about the effect, and then we'll get into all the nuances of what is a hospitalization, what is an amputation, what are the time periods mean for this rule. The rule was finalized in 2014, became effective January 1st, 2015. So we are now almost 3 full years into the rule. We've had some good lessons learned, and we'll share those at the end of the program. All of the state plans were required to adopt a reporting rule that was at least as effective. And so as a result of this, most of the state plan states have a rule that is either identical to the new FedOSHA rule or more expansive. More events need to be reported. And the best example of that is Cal-OSHA out in California has a broader definition of reporting and actually has shorter deadlines to report. So we'll talk a little bit about the distinction between those two. But all of the states have at least the events that we're going to talk about today must be reported, and they must be reported by at least the same time periods of 8 hours for fatalities, 24 hours for the other serious injuries, although some have more stringent time periods and a broader category of events. There was an expectation when the rule was promulgated that there would be a dramatic increase in the number of hospitalizations and amputations that are being reported to OSHA. And then one estimate in the rulemaking was that there would be 100,000 more events being reported. And that has not been borne out so far, but we will keep an eye on that as the years progress. And we have some ideas. I've got a couple of slides on the data here, and I'll share my thoughts about why the numbers have not measured up to what OSHA expected. But there have been absolutely a dramatic increase in the number of events that are reported, just not to that 100,000 level yet. And, we're talking about the potential impacts of this rule. More reports to OSHA means more inspections by OSHA, and more inspections by OSHA means more citations. The fact of the matter is that the average number of clean inspections, OSHA shows up at your facility and leaves without issuing at least one violation, is about 15%. So in 85% of the time that OSHA shows up, they're going to issue a citation. That number is even higher when they show up as a result of a serious injury. So here, we're picking up the phone, calling OSHA hundreds more times, thousands more times than we used to. That has resulted in thousands more inspections as a result of reportable events, and you know, more than thousands, well, some magnitude greater of citations being issued. So that's the practical effect of the rule. One other effect of the rule, through guidance by OSHA, is an increase in the penalty for failure to report. There has always been, by policy in OSHA's Field Operations Manual, a minimum penalty for failing to report. You know, under the old fat cat rule, the fatalities and 3 or more hospitalizations, OSHA would fine you at least $1,000 if they determined that you did not report or did not report timely. They've increased that to $5,000. And I have assumed that that was sort of for the initial phase of the rule, you know, to make sure that they got the word out there that there is this new rule, and so there would be a greater penalty so that those could be broadcast and people would learn through the grapevine or be scared into reporting where otherwise they had not historically. And we've seen plenty of these $5,000 penalties. That number was before the penalties increased, you know, the 80% penalty increase that OSHA was granted authority to do by Congress. I don't believe, though, that the minimum penalty for failure to report has gone up by that 80%. I think it's still set at $5,000, although because they are issued as, you know, other than serious violations, that maximum penalty authority did increase up to $12,675 or something like that. And there are circumstances, and in the Field Operations Manual, you know, the national office says to area offices, if you think that there is a need to go to the maximum penalty because of, you know, the need for that deterrent effect, or there's some special circumstances in the rule, even if you don't go to a willful violation, feel free to go to the maximum penalty even for these reporting violations. So that's the lay of the land there. Lindsay is going to get into the nitty-gritty about what exactly it means to be a hospitalization, what is a reportable amputation, and what do these deadlines actually mean.
All right. Thanks, Eric. So as Eric described, this standard does lay out, you know, specific types of incidents and outcomes that would require an employer to make a report to OSHA. And, you know, one of those types of outcomes is an inpatient hospitalization. And that characterization of the hospitalization as inpatient is really important because it does limit the types of hospitalizations that do actually have to be reported to OSHA. So in the standard, OSHA defines inpatient hospitalization as a formal admission to the inpatient service of a hospital or clinic for care or treatment. Based on this definition, the mere fact that an employee goes to the hospital does not necessarily mean that this is a reportable hospitalization. There has to be a formal admission to the inpatient service of the hospital, and there has to be medical care or treatment provided after that formal admission. So both of those criteria have to be met for the hospitalization to be reportable. Therefore, if an employee is not admitted to the inpatient unit or is only admitted for observation or testing, these both instances would not be a reportable hospitalization. Even if an employee spends multiple hours in an emergency room, gets treatment in that emergency room of some form during the multiple hours that he or she is there, if there's no formal admission to the inpatient unit, then that hospitalization wouldn't be reportable. And then even if there was admission, if they already received the treatment in the emergency unit, and so once they were in the inpatient unit were just being, you know, observed by a medical healthcare physician, that incident still would not be reportable because the inpatient admission only resulted in observation. And you'll see on this slide that the standard no longer requires an overnight stay to trigger reportability. But that's not really necessarily a significant change, because if you have an overnight stay, normally this would be an admission into an inpatient unit when this would occur. However, even then, if the employee was only observed during the overnight period, they didn't get any medical care or treatment at that point, then this would still not be a reportable hospitalization. And there has also been some confusion around the term admission, as it's interpreted differently by insurers, the hospitals or clinics themselves, as well as those of us outside the healthcare industry. As a result, OSHA has indicated that the focus should be more on this concept of inpatient versus outpatient, because these particular terms are better understood universally and have already been defined in OSHA's guidance. So in trying to determine whether a hospitalization would be reportable, an employer should first look at whether the employee was formally admitted into the inpatient unit of the hospital. And we have had discussions with OSHA about this, actually, to make sure that we accurately understood, the timeline of this and the different factors that have to be met to be able to be a reportable hospitalization. We have actually spoken to an OSHA official on the enforcement side of the agency back, closer to when this rule first came out, about, this chronology of injury and then treatment and formal admission. And this person conveyed that it is not just about whether there was treatment in conjunction with an admission, like did the employee receive treatment at any time. It has to be medical treatment that follows the inpatient admission. And we actually this slide shows the two examples that were discussed during that conversation. So the first is an employee breaks their leg, they go to the emergency room, and in the emergency room the leg is set, and they're given a prescription drug to help, relieve the pain that they experience because of the break. This would not be a reportable hospitalization because the employee was not actually admitted into the inpatient unit. All treatment was provided in the emergency room, and the employee never left the emergency room. This is where they spent their entire time, and they left thereafter. This would not be a reportable incident. The second example, similarly, the employee breaks their leg, goes to the ER, but when they're in the ER, they begin to bleed out. Also in the ER, they are given blood to replenish what they've lost, and they also then have their leg set as well. The employee is then admitted to the inpatient unit where they're monitored because of this blood loss. This would also not be a reportable event because the hospitalization, hospitalization portion did not have any medical care or treatment, which is required by the standard.
Go back to that slide. One interesting twist on this that took me a while to understand about the rule, and I don't know, maybe you already talked about this, is that there's the requirement that Lindsay talked about that there must be medical treatment after the inpatient hospitalization, after the admission to the inpatient service. I had always understood that meant medical treatment beyond first aid, because that's how you evaluate whether something is recordable. The reality, though, is the way OSHA interprets the rule now is that it doesn't have to be medical treatment beyond first aid. It has to be literally any form of medical treatment at all. So even if it is a very simple first aid form of treatment after the admission to the inpatient service, OSHA would expect that to be reportable if it occurred in the right time period, which Lindsay will talk about later. So that's an important distinction between sort of how we analyze whether something is recordable. It is a different analysis for whether it triggers reportability for medical treatment after the admission to the inpatient service.
And what Eric just explained is actually in OSHA guidance, and OSHA bases this on the fact that unlike the recording portion of the rule, the reporting portion simply says medical care and does not caveat that with medical treatment beyond first aid.
And there's a couple of questions that are popping up here about, using this example about administering prescription drugs. Does that constitute medical treatment? Absolutely. We actually use that example because that would be considered medical treatment beyond first aid, but it doesn't even need to be. If you were given drugs that were over-the-counter at over-the-counter strength, that would still be considered medical treatment under the reporting rule, although not under the record. For recording purposes, it would have to be medical treatment beyond first aid. For this, it doesn't even need to be a prescription drug, but absolutely giving a prescription drug would be considered medical treatment for purposes of the reporting rule.
Okay, so in addition to hospitalizations, OSHA also did add amputations as a category that would require an injury report to OSHA. And amputation has been defined as a traumatic loss of an entire or part of a limb or appendage that has been completely severed, cut off, or amputated. So this does include both a full and a partial amputation. The term partial amputation is not specifically defined, but based on the available guidance, we understand it to mean the full severing of a part or portion of an appendage. So, for example, the loss of the top of a finger beyond, above the first knuckle would be a partial amputation. Again, this is our understanding based on available guidance. OSHA has not yet provided any clear interpretation on this point. Although the rule does not make completely clear what would be considered a partial amputation, it does explicitly lay out what would not be considered an amputation. And this includes avulsions, scalping, severed ears, and broken or chipped teeth. Importantly, in determining whether something is considered an amputation and therefore potentially reportable, OSHA will put great weight on the diagnosis of a healthcare professional. So if the employee is seen by a healthcare professional and that healthcare professional characterizes this as an amputation, OSHA would see it as very strong evidence that indeed this was an amputation and should be reported if it meets the other requirements of the standard, which we'll talk about a little bit throughout this presentation. However, there are some important considerations to know which the employer should keep in mind when analyzing whether an amputation is reportable. And one of the most interesting parts of the rule, and what we have received a lot of questions on related to the rule, is OSHA's clear directive that amputations do include the loss of the tip of a finger with or without bone. So they haven't really provided guidance beyond, the blanket statement that it is the loss of a tip of a finger with or without bone. But we have interpreted this to mean that OSHA would consider really any loss of some portion of the tip of a finger as reportable. And due to such a broad interpretation, this type of injury may actually require reporting of an amputation that didn't require medical treatment and thus may not even be recordable. For example, if an employee just loses a very small portion of the top of the tip of their finger, this may be addressed by some antiseptic and a Band-Aid, which means that it wouldn't be recordable because there was no medical treatment as long as it didn't result in days away from work or a job transfer, which this type of injury likely wouldn't. But it would still be reportable to OSHA because of this very broad definition that OSHA has provided regarding amputations of the tip of a finger.
And I would just say, I've talked to a lot of medical professionals about this, and there is no way to reconcile this sort of definition of fingertip without bone loss with the exclusion of avulsions, enucleations, and deglovings. This is basically, I can't remember whether it's an avulsion or an enucleation. It's one of those two, just of the tip of the finger. It's an avulsion of the fingertip, but OSHA has carved out an exception. No avulsions are reportable except for an avulsion to the tip of the finger. And speaking with my friends at OSHA, the explanation is that a fingertip amputation tends to be a sign or an indication of an inadequate guarding or inadequate lockout-tagout program or something like that, and they would treat that or think of it as essentially a near miss. That even though it was not a more substantial amputation, it is perhaps very illuminating as to the effectiveness of your guarding or lotto program, and they're going to want to take a closer look at that. But the exact same situation, if it's not the tip of your finger, and I read this fairly liberally, that if it's the side of your finger or your hand or your arm or something like that, that's an avulsion. Just as the fingertip avulsion is, and it's not a specific form of avulsion that's been, expressly carved out of that exclusion. So if it's not the tip of your finger, apply the avulsion analysis and go from there.
And then finally, the rule also includes medical amputations, which means that if a particular injury results in a doctor later having to remove a particular part of the body. For instance, you might see this where an employee, crushes their finger in a machine and the determination is made that the finger should be amputated for the health of the employee. This could also potentially be reportable if it occurs within the established time frame in the standard, which again we'll talk about a little bit in these upcoming slides.
One thing I would say about amputations is the analysis is very dependent on what's in the medical record. And I don't know if that's you're about to cover that, so I'm sorry to cut you off. But we have found that OSHA takes a pretty grants a lot of value to what the doctor says in the report. So if a doctor calls it an amputation, even if in your judgment it's not, they're going to scrutinize that and perhaps say that you failed to report if you decide to not report it and they find out about it otherwise. Likewise, if a doctor characterizes it as an avulsion or a nucleation or something else, you're going to be in a pretty strong position to say that it's not a reportable amputation because the doctor declared it to be some other type of injury, even if in your non-medical opinion it appears to be an amputation. So what the doctor says in the medical records is important, and that's one of the things that you should analyze when you're trying to decide whether you need to report the injury to OSHA.
All right, so beyond just how the term amputation is defined and the different forms that an amputation can take, there are a number of interesting issues that have come up related to amputations. And many of these issues arise from the fact that, as Eric pointed out in the last slide, OSHA is very interested in amputations and following up on amputations. They see this as a really significant issue. For example, the rule requires an amputation to be reported separately from an inpatient hospitalization and vice versa. Thus, if an incident is first reported as an inpatient hospitalization because the employer becomes aware that the employee has been admitted to the inpatient unit and has received, treatment in the inpatient unit, but then later results in a medical amputation within that 24-hour time frame provided in the standard, that same incident has to be reported separately as an amputation. And then alternatively, if an incident happens at the work site and it's very clear, that an amputation has occurred, and so the employer calls OSHA and says, we have an amputation. If the employee is then later admitted to an inpatient unit where, for instance, if some sort of surgery is performed on the affected area, then the employer also has a responsibility to call OSHA and let them know that this incident has also resulted in an inpatient hospitalization. OSHA wants to hear about both, amputations and inpatient hospitalizations, even if they are, occurring just in one single event. And you'll see on this slide there is also actually a separate reporting requirement for specific types of amputations under the standard that regulates the use of power presses. So this standard creates a separate duty for employers to report all point of operation injuries that occur to operators of these mechanical power presses within 30 days of the occurrence of the injury. So this is important because there may be instances where an amputation results, but for some reason it doesn't meet the criteria for a report to OSHA under this particular standard, and maybe it doesn't occur within the 24-hour time frame, the employer has to still be careful and assess, was this a power press that caused the injury? Because if it was and it falls within this standard, then the employer still may have a responsibility to report the injury, the amputation, to OSHA within that 30-day time frame from when the injury occurred. And then finally, there is still an active amputation national emphasis program. And again, this just further emphasizes the priority that OSHA has placed on amputations and its ability to be aware of amputations and follow up on those specific types of injuries. The current version of the NEP requires that for certain employers meeting the specific NAICS codes that are outlined in the National Emphasis Program, OSHA will perform an on-site inspection when it receives a report or information that an amputation has occurred. This may trigger the National Emphasis Program, and OSHA may come inspect under the National Emphasis Program. So this slide just lays out what types of injuries and illnesses would not be reported to OSHA under this particular standard. And you'll see the two at the bottom we've already kind of talked about. But the two at the top here are both actually explicitly laid out in the standard. And they would exclude an employer from reporting an injury or fatality that results from a motor vehicle accident or an incident that occurs on commercial transit or public transportation system. These types of incidents may still be recordable and likely are recordable. I mean, a motor vehicle accident would likely result in the need for medical treatment or potentially days away from work. So it would still likely be recordable on the 300 log, but would not result in the employer having to make a report to OSHA of that particular incident.
And just for my construction friends that are on the call, if it is a construction-related incident on a public road, that is still potentially reportable if it meets one of the other criteria. This is for sort of the traditional auto accident situation, would not be reportable even if it's recordable, but that is there's a carve-out for the construction incidents that occur on the road.
Okay, so another essential factor that an employer needs to consider in determining whether an incident is reportable is whether it is actually work-related. So similar to recordability, fatalities, amputations, inpatient hospitalizations, or the loss of an eye would only be required to be reported if they are work-related. And there are a lot of nuances to this assessment of work-relatedness that are important to navigate and trying to determine whether an incident is actually reportable. So generally, OSHA has said that an injury or illness is work-related if an event or exposure in the work environment caused, contributed to, or significantly aggravated that injury or illness. And OSHA does use a geographic presumption that if an injury or illness occurred in the work environment, it would meet that work-related definition. However, there are some exceptions to that presumption that we'll talk a little bit about here and then in the next slide as well. It is also important to note that there is no consideration in this assessment to the particular sensitivity of an employee in determining whether the injury or illness is work-related. For example, if an employee has particularly frail bones and they trip and fall and they fracture their leg, in a circumstance where any other employee would probably have just had a bruise. That doesn't mean that their injury should be treated any differently. It would still need to be recorded based on the outcome that results from the injury and potentially reported if it did result in an inpatient hospitalization.
This issue is becoming more and more relevant and important as our workforce continues to age. We have workers who are staying at work much later in life, and a much, much larger population of senior people in the country, and therefore a much greater population of senior people in the workforce. So there is this, no eggshell exception includes things that might otherwise not be, would not affect another employee, would not even result in first aid treatment, becomes a more serious injury for a senior worker. The same is true for events where, the employee falls in the workplace, where another employee might not have had any trouble with that, but because seniors are more inclined or more likely to have balance issues, motor skill issues, and have an increased likelihood of falls in the workplace, those are predominantly going to be considered work-related. There is a question already in the queue here about somebody who sort of loses consciousness because of a non-work-related illness. That's not work-related. That's not going to be reportable or recordable. But if somebody falls, not necessarily because of a wet spot on the floor or an uneven floor, but they fall just walking around the workplace, not because of some other illness, but just because they're maybe clumsy or they've got motor skill issues, that's still going to be reportable if it results in one of the reportable criteria. So that eggshell exception issue is becoming more and more significant as we're dealing with an aging workforce.
And that question is interesting, and I'll talk about that a little bit now, because there is an exception to work-relatedness that is associated potentially with a particular condition of an employee. And that exception is where an injury or illness is caused by signs or symptoms of a non-work-related event or exposure that just surface in the workplace. And one example that we've seen come up before is the case of an employee with epilepsy. And the epilepsy causes a seizure at the workplace, and during the seizure, the employee, falls, loses consciousness, and hits their head on, a desk or something nearby, causing an additional injury to the employee, this laceration from contact with the desk. In that circumstance, because epilepsy is a non-work-related condition, and the seizure is just a symptom of that condition that happened to arise at the workplace, the resulting laceration caused by the seizure would not be considered work-related as it falls within that exception. Thus, if this laceration were treated after an employee was admitted into an inpatient service, the hospitalization still wouldn't be reportable because that laceration, that injury, is non-work related, and it has to be work related to be reportable. So when assessing work relatedness for purposes of determining recordability or reportability of the particular incident, the standard OSHA uses and the standard that an employer should use when making this determination is whether an event or exposure in the workplace more likely than not caused or contributed to the injury or illness. So this concept of more likely than not is really important, as is the fact that the exposure in the workplace really only has to be a cause or a contributing factor. It doesn't have to be the sole cause or the sole contributing factor to the injury or illness. An example of where we have seen this come up related to the reporting rule is actually in the context of assessing a heart attack. So the rule actually specifically addresses this type of incident, and it does require employers to report an inpatient hospitalization or death caused by a work-related heart attack. And that caveat, that work-related heart attack, is really important, particularly in this context. So that exception that I mentioned earlier, where an event or where signs or symptoms of a non-work-related condition surface in the workplace, this does not make the resulting injury work-related, and this is actually an exception to work-relatedness. So if an employee has hypertension or another type of heart condition, the heart attack in a workplace may just be a symptom of this non-work-related issue that is surfaced at this time. And so if that's the case, if it's solely related to the hypertension or the other heart condition that is not work-related, then it may not be a work-related heart attack and wouldn't have to be reported. However, for the exception to apply, the sign or symptom has to be the sole cause of any resulting injury or fatality. And in the case of a heart attack, if the employee was performing particularly strenuous work at the time that the heart attack occurred, it's likely that OSHA would see this strenuous work as a contributing factor or as one particular cause of the heart attack that resulted. And in that case, the heart attack would likely be seen as work-related by OSHA and should be reported to OSHA by the employer. But again, the circumstances are really important in each instance, and so it's important to carefully assess, what actually caused the heart attack in each case and whether anything in the work environment could have been a contributing factor or a cause of the heart attack. So this slide shows the relevant time frames in which each type of reportable incident has to be reported to OSHA. Importantly, the standard does make clear that these time clocks laid out here begin when the employer or an agent of the employer, which is a supervisory employee, a management employee, obtains knowledge that a reportable event has occurred. So the standard does actually recognize that an employer may not always have immediate knowledge that, an injury resulted in, for instance, an inpatient hospitalization. And I think this is especially true with inpatient hospitalizations because you have the multiple factors and the elements that have to be considered in determining whether it's reportable to trigger that particular time frame associated with the specific outcome. So in the case of a fatality, a report has to be made within 8 hours of when you learn of the fatality. And in the case of an inpatient hospitalization, the employer would have to report within 24 hours of learning the employee was formally admitted to an inpatient service and received medical treatment. And then for an amputation or a loss of an eye, it would be within 24 hours of learning of the relevant amputation or loss of an eye. And this is actually also true in determining work-relatedness. The standard specifically states that the time clock for reporting begins only when an employer or, again, one of its agents, a supervisor, a manager, maybe of the employee, learns that the injury or illness was caused by a work-related incident. So again, there is some time there to assess whether, the exposure in the workplace was what actually caused the outcome that may require reportability. Although the employer does have some leeway here, it does have to make reasonable good faith efforts to obtain this information promptly and meet these time frame requirements for reporting. And beyond the time in which a report must be made, there are also important time frames laid out in the rule for what constitutes a reportable incident. I'll just go back to the slide real quick to go through these time frames. So a fatality is only reportable if it results within 30 days of the incident that would have caused it. And then for hospitalizations, amputations, and loss of an eye, they must occur within 24 hours of the incident as well. So because of the nuances that we discussed in the context of hospitalization and the fact that the key circumstances for assessing whether a hospitalization is reportable may not be available to the employer immediately, hospitalizations can be a little bit tricky in the specific time frames in which they have to be reported. For instance, if there were two employees working in a shipping area and one employee really badly cut his hand and the other employee, instead of notifying management that this occurred, just decided to put his coworker in the car and drive him to the hospital, the employer may not even be aware that the employee left work and went to the hospital. So it might not even have any context at that point that it should be looking into whether the employee was admitted, whether they did receive medical treatment after they were admitted. So this is sort of an issue that is unique to the inpatient hospitalization context. Similarly, even if the employer knows that the employee was taken to the hospital, but they don't get any sort of medical information right away, they are unable to obtain documentation from the hospital that indicates whether the employee was admitted or not, this may push off the time clock in which they have to make the report because they don't have the necessary information. Another interesting note in the context of hospitalizations is that hospitalizations can also actually be caused by illnesses. And this can bring sort of a unique dilemma to determining when the 24-hour time clock in which a report must be made, but also the 24-hour time clock, to constitute a reportable inpatient hospitalization has actually started. In the case of an illness, the triggering event is a time when the employer can best discern that the employee was exposed to the chemical, the contagion, or whatever, the bacteria, or another work-related condition that might have actually caused the illness. And this can be really difficult to determine sometimes. It could also be the case that, an employee was exposed 2 or 3 days prior to when they actually ended up having to go to the hospital for treatment. And in that case, the hospitalization, if the employee is admitted and given treatment after they're admitted, that hospitalization would still fall outside of that 24-hour time frame between when the exposure occurred and when the employee was actually hospitalized. So that would still not be a reportable incident, even if the employee was in the inpatient unit, because it occurred, 3 days after the event that would have exposed the employee to the particular contagion that caused the illness. And then this slide shows some three common timing issues that we've seen arise, particularly in the context of these specified time frames in the reporting rule. So the first here is a delay in the formal admission to an inpatient service. We've kind of talked about this already, but it's interesting to note that hospitals are reimbursed at a higher rate by their insurers for emergency service over an inpatient admission. Therefore, hospitals are motivated to keep and treat patients in an emergency room context or in the outpatient service for as long as they can, which could exceed, again, that 24-hour time requirement between when there was this occurrence that caused the injury or illness requiring the hospitalization and the actual inpatient hospitalization. More specifically, for a hospitalization to be reportable to OSHA, an injured employee has to move beyond the emergency service to formal admission in the inpatient service and then also receive medical treatment or care on top of that within that 24-hour time frame to make it reportable. So this is important to keep in mind when assessing, whether an inpatient hospitalization should be reported. For medical amputations, employees receiving a medical amputation may be released from the hospital before the medical amputation is actually conducted and directed to return within a couple days, or it may take some time. There might have to be a consultation between the patient and their healthcare physician to decide if a medical amputation is the best course to treat the injury. So if this occurs, then again, when the medical amputation actually occurs may fall, outside of that 24-hour time period from the original occurrence that caused the injury, now requiring an amputation. And then the last example we have here is more of an issue, again, of chronology. Inpatient hospitalizations, again, only need to be reported if the employee receives medical care after admission. So that timing is really important. If the medical care was received before they were actually admitted, then that instance would not be a reportable inpatient hospitalization.
And just to add to that briefly, it has been sort of remarkable to us how often those 2, 1 and 3, that those timing issues have resulted in items that were apparently reportable, and that the instinct of our client was that this is reportable, became non-reportable events that we determined or learned that the admission to the inpatient service occurred at hour 25, because there's some period of time before the employee gets to the hospital, and the hospital keeps the employee in emergency status for 23 hours and 59 minutes, which by a lot of insurer programs is the maximum amount of time that you can be in the emergency status. And they're doing that. They're keeping them there in that status on purpose because they get to charge more for the treatment they provide in those circumstances. I've been sort of blown away how often the formal admission does not occur within 24 hours of the incident. So that's an important one to really pay attention to and to try to gain access to information about that. It's a great question here from one of the participants that says, how do we demonstrate that we're making these good faith efforts to get that information? And the answer is the answer is in the question itself. Email strings, detailed notes about when phone calls were made, to whom you spoke, what you learned, what you were told. And if you're not getting access to information because they're denying you the access to the information, which is a big issue under HIPAA rules or a misunderstanding of HIPAA rules, often it's hard to get that information. You try to get it from the individual employee or a family member, spouse, girlfriend, whoever's visiting with the employee at the hospital. Document the efforts that you've made to get the information from them. Document the efforts you've made to get the information from the hospital. And all of that, to me, until you know, you don't know, and you don't have a duty to report for 24 hours for a hospitalization until you know you have good information that a reportable event has occurred. And then often we find out, so surprisingly often we find out that it does not actually trigger a report because of one of these three issues. So interesting stuff.
Yeah, I mean, we're definitely reiterating these things because the rule has now been in place for a couple of years, and these are the types of things and issues that we continuously see come up and are asked questions about. So we want to make sure that everyone has, a strong understanding of this. So I'm just going to take a couple more minutes here to go through, questions that we have seen come up surrounding actually making a report. A reportable incident has occurred. Now you have to make the report. And one of the questions that we get is who has to make that report. And we often see this in the context of a temporary worker relationship or, on a multi-employer work site where it's a little unclear whose responsibility it is. And essentially what it comes down to is the employer who records the injury or illness is also going to be the one that reports. And this is the employer that provides the day-to-day supervision of the injured worker. OSHA has stated that this is generally the employer that controls the conditions presenting the potential hazard to the employee or the condition that actually caused the injury in this particular instance. The employer that directs the worker's activity around those hazards. It's usually going to be that employer whose responsibility is to make the report. And in the case of temporary workers, we see this most often being the host employer, but it is dependent on the relationship established for the particular work that's being performed at the particular work site. Again, only one employer should make this report, so it is important. You don't really want multiple employers calling OSHA and making the same report. So it's important to understand, where this responsibility falls. And then this slide just lays out the types of information that will have to be provided when a report is made. As we'll discuss really briefly in the next slide, we do recommend making the reports to OSHA by phone. So you want to make sure that you have this information, readily accessible to you when you make the call to OSHA to report, the inpatient hospitalization or the amputation, whatever it may be. Beyond these questions, OSHA may also ask the age of the injured worker. It may ask how many employees are at the work site and whether the employee was a temporary worker. So it's helpful to have this information available as well. So as Eric said earlier in the presentation, OSHA does provide a web portal through which you can make a report. We've seen that this portal is very similar to one that OSHA created to allow employees to make whistleblower complaints. And as a result of giving this portal to employees to make whistleblower complaints, we actually did see a huge surge in the number of complaints that were filed with OSHA. And I think, OSHA had a similar thinking here, that putting this site together, making it easy for employers to report, would make reporting more conducive, would make employers more likely to report, and that OSHA would see an increase in the reports that are made. It is also, an added benefit to OSHA to have information regarding a particular injury or illness in writing. But we have actually cautioned our clients against using the web portal for multiple reasons, one of which is because this requires that an employer commit to writing what occurred, what the injury was, why it happened, at a point in time where they haven't really had the chance to do a full investigation of what actually happened. And OSHA can then attempt to hold the employer to these statements that were made without the benefit of all of the relevant information that might come out later in the context of a potential enforcement action. The 8-hour time frame for reporting a fatality and the 24-hour time frame for reporting an inpatient hospitalization, amputation, or loss of an eye is usually not sufficient time to actually be able to fully understand the facts that are necessary to make this report to OSHA, such as why it occurred or what actually caused it to happen or what even actually occurred at all. Employers will often be able to get this information later, but if they've reported through this online system, they've already kind of laid that out for OSHA. These types of documents could also potentially be FOIA'd and accessible to a plaintiff's attorney, for instance, if the injury resulted in a personal injury proceeding from the employee. OSHA does also seem to ask a lot more questions in the web portal than they do when an employer reports by phone. And from what we've seen, it seems like the questions are very similar to the rapid response investigation request, which Eric will talk about in a little more detail shortly. So the telephone report is usually very basic, exactly those types of questions that we had on that prior slide, and thus using the web portal may actually give OSHA access to more information than they would normally have if reported by phone. And then finally, with any electronic site or electronic submission, there are these concerns about security risks. These forms do request information that could be sensitive health information of the injured employee. So just another thing to keep in mind and be careful about, if you were to use this web portal, there may be some risk that somehow this information could be accessed. And with that, I will turn it over to Eric.
All right. I know that we're running pretty long here, so I'll try and move through these last few slides pretty quickly. We include this slide here just to talk about what was the purpose of this rule. And this is David Michaels, the former administrator at OSHA during the Obama administration, speaking at the time this rule was promulgated about what it was all about. And it's pretty obvious. The concept here is that according to Dr. Michaels, and I think very clearly, this will allow OSHA to now receive crucial reports of fatalities and severe work-related injuries and illnesses that will enable the agency to target its resources. And what he's talking about there is targeting the agency's enforcement resources. If you're just looking for trends about types of injuries and injury data, you can get that through the electronic record-keeping rule, through the BLS surveys and things like that. If you're looking for reports of certain types of injuries within an 8 or 24-hour window, you're talking about enforcement. We want to know about it, OSHA says, so that we can get our enforcement resources dispatched to these situations for enforcement purposes. And that's exactly what we've seen happen here. OSHA issued guidance and has updated that guidance over the last 3 years to talk about what's going to happen after a report has been made. And really there's three choices. One is we're going to see an on-site inspection from OSHA. I guess there's four choices. One is that on-site inspection from OSHA, and we know what's going to happen then. 85% likelihood of at least a citation, at least one citation being issued, and probably higher than that for these reporting incidents. Or OSHA is going to send you a letter that says, we'd like more information about this incident. We'd like to know what you're doing to address the hazards that were involved in the incident, and you hope that's the end of the inquiry. A third outcome is they send you that letter, collect some information from you about the incident, and then decide to initiate an on-site inspection. A pretty bad scenario there because you've just responded to their request with some admissions about the incident, and now they're starting an enforcement inspection. And then a fourth category is nothing happens. And I'm not aware of too many of those nothing happens incidents. The only situations where I've seen nothing happening, not even a letter requesting you to explore the incident more, is when the report was one that shouldn't have been made at all, and it is just so far afield that OSHA is not even interested at all. Like a fatality, heart attack for an employee who's been at work for 5 minutes and was just sitting at their desk, not work-related at all. They'll just say, well, thanks for calling, but that's not something we're going to look into. Everything else triggers one of those other outcomes. And the guidance that OSHA issued explained what is most likely to trigger an on-site inspection, what is most likely to trigger that letter, and I'll talk a little bit about what that letter is all about as well. Category 1 are those events that you're reporting to OSHA that trigger an automatic mandatory compliance officer is coming to your facility for an inspection. That is, they say all fatalities, but again, it's really all work-related fatalities. We've seen a lot of courtesy reports that I think are a bad idea that sometimes OSHA disregards, but for the most part, every fatality is going to be inspected. Inpatient hospitalizations of 2 or more employees are apparently automatically get an on-site inspection. So we're now reporting single hospitalizations, but if it's 2 or more, guaranteed OSHA is going to show up. If the injury that you report involves an employee who is younger than 18 years old, a youth worker, that's going to trigger an on-site inspection. If there is a known history of injuries, same or substantially similar incidents have occurred at your workplace in the past, they're going to conduct an inspection. So maybe the first time you had a hospitalization for a certain type of event, OSHA sent you one of these rapid response investigation letters, but the second time they're going to come on site and find out why there's this systemic problem at your workplace. If you are a repeat offender, already a repeat offender, by the time you make this report of an injury, you've got a history of either willful violations or those failure to abate repeat violations, which make you a real repeat offender. Apparently that's an automatic trigger for an inspection. This is an interesting one that I'm not quite sure how to reconcile with some of the data, is that if the issue that you report relates to a national or local emphasis program, that triggers an automatic inspection, an automatic on-site inspection. One of the national emphasis programs that has been in effect for the entirety of this new reporting rule has been the Amputation's national emphasis program. But as you'll see in some of the data report, there's not a 100% inspection rate for amputation, so I'm not quite sure how to reconcile that. But the reality is, if it involves an amputation, if it involves a process safety management incident, if it involves trenching, excavations, things like that, where there are active national emphasis programs, you are, almost certainly going to see an on-site inspection. If you're already on OSHA's dreaded severe violator enforcement program list and you report an injury to OSHA under this new rule, that is going to automatically trigger a site inspection. And then any report that involves something that OSHA would characterize as an imminent danger will also trigger an inspection. There is the second category. If it doesn't fall into category 1, there are these squishy factors that the area director gets to evaluate based on the information you've reported and perhaps a follow-up request for information about the incident, that based on these squishy factors, they get to decide whether they're going to do an on-site inspection or do the rapid response investigation protocol. And those factors, I'm not going to go through all of this in detail, but it includes sort of an analysis about how serious the incident was, how effectively you've addressed it since the incident occurred, whether there are employees who are still exposed to the hazard, those sort of things. And then also how much it relates to one of the programs that OSHA so loves to enforce, from their top 10 lists of violations. Does it involve a safety program failure? They might ask you some questions about how you implement, how you communicate your safety programs to employees, and make a decision then about whether they're going to do an on-site inspection. Here are some more factors that are part of that. Is the employer a VPP or SHARPS participant, somebody who's involved in the cooperative programs? And the analysis here is sort of the backwards of what you might hope. If you are a VPP employer, you're more likely to get the site inspection because you're otherwise excluded from programmed inspections. So those are one of the things they look at. They look at your inspection history. They look at whether there is a related whistleblower complaint or any other whistleblower complaint going on actively at your site, more likely to trigger an on-site inspection. So this is the, what happens if it's not one of those things, or if the squishy factors leads the area office to conclude that they don't need to do an inspection. That's when Category 3 is triggered. And Category 3 is this rapid response investigation protocol. And this is the letter that OSHA sends saying, thank you for your report of injury. At this time, we have not decided to initiate an on-site inspection, but we're going to ask you to do it for us. And we want you to do an investigation of the incident that you've just reported to us and report back to us at OSHA about the root cause of the incident, about the findings for contributing factors to the incident, what corrective actions you've already taken or determined are necessary and plan to take. And based on the response that you make to OSHA, then an inspection may occur. This protocol was introduced because of the expectation and the realization of a substantial increase in the number of incidents reported to OSHA. Historically, OSHA responded to, with an on-site inspection, almost all reports of injuries because they involve fatalities or really significant events with hospitalizations of 3 or more employees. So they were dispatching on-site for all of those, with the expectation that they would get tens of thousands, maybe even 100,000 more reports of injury. They needed a triage tool to be able to deal with this because they can't do 100,000 inspections, right? Every year, FedOSHA does about 40,000, now about 35,000 inspections. So there would be no way to respond to all of those and still do programmed inspections, complaint inspections, and things like that. So this tool was developed to triage this expected increase in reportable incidents. So the tool asks you to do OSHA's job for them. Inspect, identify things that went wrong, and tell us how you're going to correct them. The vast majority of responses to these RRI letters do not trigger an on-site inspection. So it's really good news when you get one of these letters. You're almost in the clear when you get one, but there are some strategies we'll talk about briefly about how to make you less likely to get that subsequent on-site inspection. Talk a little bit about some data here that we think is kind of interesting about this rule and what we've seen since the rule. Here's what we've seen in terms of injuries being reported. And this is just FedOSHA data, and this is just hospitalizations and amputations. It does not include fatalities. And every year there's about 4,000 to 5,000 workplace fatalities around the country. I figure about half of those are in FedOSHA states. So we'll add another 2,000 or 3,000 fatalities into this. And we're seeing about 14,000 incidents being reported to OSHA every year. Historically, again, if we're just talking about federal OSHA, you're talking about fewer than 3,000 every year, about half of the fatalities and just a few dozen, a couple dozen, maybe even less than that, of the multiple hospitalizations. So you can see that we've seen a huge growth in the number of reportable events. incidents where you got to pick up the phone and call OSHA and basically invite them into your workplace. This table also includes how OSHA responded to those reportable incidents. 27% of the 8,100 hospitalizations that were reported to OSHA triggered an inspection. That's about 2,100 inspections were conducted based on a hospitalization report last year, and that's going back to those categories. Many of those probably involved national emphasis programs or repeat offenders or things like that, or the area office applied their squishy factors test and determined that an inspection should be done. 49% of amputations, almost half of the amputations that are reported, about 1,300, resulted in an on-site inspection. The rest resulted in a rapid response investigation protocol being followed. From a total standpoint, that averages out. Again, this does not include fatalities, so we're looking at about 33% of the hospitalizations and amputations that were reported to OSHA resulted in an on-site inspection. That means I'm not great at math, but well more than half of these did not result in an on-site inspection. However, if you do factor in the fatalities, you do get to about 50% of every time an employer picked up the phone to call OSHA about an event, you had an on-site inspection. The number, another thing that I find interesting in the data is if you look at the total number of reports in 2015, the first year that that this new reporting rule was in place, you had 10,300 reports. The next year, 2016, these are calendar year numbers. That increased by about 500 to about 10,900 reports of injuries. We have data for 2017 through the month of October. That data annualized looks like it'll be about 11,500 reports, hospitalizations and amputations, again, not including your fatalities. So every year it's gone up. The first 3 years, 10,300, 10,800, 11,500. What I find most interesting about that is maybe you all have seen some of the articles that have come out just recently as the BLS data has been reported, that for fiscal year 17, we had the lowest number of work-related injuries, according to BLS data, that we've had, I think maybe ever. So as we're seeing the actual number of work-related injuries decline, we're seeing the number of injuries being reported to OSHA increase. My assessment of that is that this is a new rule. In 2015, fewer people understood or even knew that the rule had changed, and so there was a lot of what would otherwise have been reportable injuries not being reported. And as more people have come to learn about the rule or have seen significant enforcement, and so they're following the rule, you're seeing a greater percentage of reportable injuries are being reported, even while the number of reportable injuries are declining. That's my guess as to why the data looks like this. Another sort of interesting analysis of the data is it doesn't look anything like what OSHA predicted was going to happen. Even if we double these, so add in your fatalities, another, call it 2,500 in Fed OSHA states. So you're looking at 14,000 in Fed OSHA states for hospitalizations, amputations, and fatalities. Double that to account for the state plan states, because this is just Fed OSHA data. You're looking at maybe approaching 30,000 total reports. OSHA expected 3 times that. A couple things I think account for that. One is what I just said. People are still learning about the change in the rule, so there's a lot of reportable injuries are not being reported. The other big one is I think OSHA, in their estimates about what was going to be reportable, did not factor in, did not account for some of the really interesting nuances that we're seeing about hospitalizations. That you've got this situation where, OSHA looks at an event that results in inpatient hospitalization with serious medical treatment, but they're not happening within 24 hours. Without thinking about the nuances of that 24-hour reporting window, or not reporting window, but the trigger to report, you're adding in a lot of hospitalizations that ended up not being reportable. So I think it's an interesting analysis. It will be interesting to see what the numbers look like year after year after year as more people come to understand what is required to be reported. As you all, leave this webinar fully informed about the new rule, what's likely to happen then. Talk quickly about some best practices and common mistakes. One thing, and Lindsay already covered this, so I'm not going to go into too much detail, but really do a really serious investigation about the circumstances of the hospitalization. Understand when admission occurred and what happened after the admission occurred, and make sure that it's actually reportable based on those criteria. And I believe strongly, and I have defended violations, and I have persuaded OSHA that we were right on these issues, that the clock does not start at the time of the incident. The clock starts when you have good reason to believe a reportable event has occurred, and while you're investigating that, if it is a good faith investigation and you don't have information that really establishes that a reportable event has occurred, your clock hasn't started to run. And don't panic that you're coming up on 24 hours from the time of the incident and make a courtesy report or a precautionary report. Finish your investigation. Find out whether it actually is reportable, and only then should you make your report to OSHA. Because I'll tell you this, and I use the word courtesy report, OSHA doesn't show you any courtesy. If you report, they're going to apply their analysis, and they're coming out. Even if it turned out it wasn't reportable, if it related to a national emphasis program, or if you've got a record, they're going to come out and do an inspection, and they're going to hammer you. So, don't do them any courtesies, because they're not going to do you any courtesies. Do the analysis, reach a conclusion, consult us. We field questions all the time. Hey, something has happened. Can you help us determine whether this is reportable? Call us before you call OSHA and make sure you've got it right. Highly recommend, as Lindsay said, calling OSHA rather than using the web portal for all the reasons she explained. Big one here. After you've reported to OSHA and you're lucky enough to get the RRI, Rapid Response Investigation Request, my recommendation, and I'll tell you, there is a difference of opinion among the OSHA bar about this. My strong recommendation is to use OSHA's form. They send you this non-mandatory investigation form and suggest here's a good tool you can use for which to fill in the information to respond to us. I feel like the smart move is to use their actual form. And we actually have this converted into a Word version. We're happy to share it with you for you to type the information directly into it. The reason I say use their form is think about your audience. You've got a field officer or a duty officer sitting there in the area office collecting these things, lots of them, and making a decision about whether they should trigger an inspection. There are certain things that they're expecting to see. And if they don't see them, that's one of the factors to say, I'm going to do an investigation because the employer hasn't told me what corrective actions they've taken. The employer hasn't told me what the causes are. The employer hasn't provided the information that we, OSHA, expect to see in the RRI form, so we're going to do an on-site inspection. Well, the best way for them to go through and check the box to say we got all the information we need is to use their form. Make it easy. Make it easy for the duty officer to check the box. So use their format. That's my recommendation. Even if that means not filling in every box or cutting one of the boxes out from the Word form, I'd prefer you didn't do that because, again, you want him to go through and say, okay, I see corrective actions. Okay, I see root causes. Okay, I see the data about the injured employee. The easier it is for them to follow and to know that you've provided all their required information, the more likely you're to avoid a follow-up inspection. Other advice that I've received from area directors, in fact, the number one common response I got from area directors as to what will trigger an on-site inspection after an RRI submission is made is if the root cause analysis is simply it was the employee's fault, employee misconduct. He didn't follow our rules, something like that. Don't exclude that, right? You want to preserve that if that's likely to be a defense if you are cited, but don't include only employee misconduct. Try to find at least some mechanical cause of the incident. Try to find some additional cause or contributing factor rather than just blaming the employee, because that drives the area office crazy and will likely trigger an on-site inspection. And then the last thing I would say is make sure you include at least one corrective action, even if it's just provide refresher training to the injured employee. Don't leave that box blank, because if there's no corrective action, you're much more likely to see an inspection from OSHA. Some common mistakes: over-reporting, making courtesy reports, and reporting non-employee injuries. That's basically three ways to say the same thing. Reporting something that you didn't have to report. We see it most often in hospitalizations. People who say, well, they left by ambulance to the hospital, I've got to call OSHA. Premature reporting, the same thing, saying, gosh, it's been 24 hours since the incident. I don't know whether it actually meets the criteria. I'm going to report anyway because I don't want to be late. And then it turns out it didn't need to be reported at all. You've made a courtesy report, and OSHA will not show you the same courtesy. Another common mistake we see on the flip side of this is failing to report those minor fingertip amputations. We see them. We see in some of the really, really minor deals where it was just a flap of skin off the front. They put a Band-Aid on it. That was the end of it. OSHA would expect that to be reported. So a lot of those are not being reported, and if OSHA finds out about it some other way and they do an inspection, you're going to get hit with a violation there. I think it's a mistake to use the online system to report. Use the telephone instead. Another big one is making admissions, either when you make the telephone report to OSHA or in the RRI response. You want to use some careful wording in how you explain causes and things like that, so you're not, just admitting right there in paper or on the phone to OSHA that you have violated an OSHA standard. That's a good circumstance to consult with your OSHA counsel, is to evaluate how to respond to that RRI request or to work through talking points for the first report of the injury. We've already talked about how you can give an inadequate RRI response that results in an inspection, blaming the employee, not identifying corrective actions and things like that. And then the last big error we see, and I see this all the time for my clients who have California workplaces, but not only California workplaces. So you've got workplaces all around the country and also in California. There was so much press, so much presentations like ours over the years about this new rule and fact sheets and FAQs and all sorts of great information about the new reporting rule that everybody just believed that that was the exact same scenario. I had to follow the same rule in California. But the reality is California has a more strict rule. It covers more incidents in a different time period. So if you're in California, and California has no sympathy for people who say, well, I thought the new rule was 24 hours, then they're citing people left and right and saying, well, we don't care what OSHA is doing. This is our rule, and you've got to follow our rule. So if you're in California, the rule is you must immediately report work-related deaths or serious injuries or illnesses to the nearest district office. And I've seen violations for falling down on all of these. You report it to the wrong district office, or you don't report certain serious injuries that wouldn't otherwise be covered by the Fed rule, or you're not reporting promptly enough. A serious injury or illness includes things that would be covered under the Fed OSHA rule: inpatient hospitalization for more than observation, loss of a member of the body. I think that lines up pretty closely to the amputation rule, but it also includes any serious degree of permanent disfigurement. And they apply a pretty broad view of serious degree of permanent disfigurement. Scars, things like that are not the result of an amputation, did not result in hospitalization, but is a pretty broad view of a serious degree of permanent disfigurement, is something that's going to have to be reported to Cal OSHA. Broken legs that are set simply in the emergency room and treated outpatient, OSHA is going to say there's a serious degree of permanent disfigurement in that type of event. You can report by telephone or email. Just like Fed OSHA's new policy, there is a minimum penalty of $5,000 for these. There's also a criminal misdemeanor in California for failing to report a fatality. A couple other nuances of the Cal OSHA rule. This is the one that trips up most people, is they're making a report of a hospitalization at hour 20, which is perfectly fine under the Fed OSHA rule, not fine in most circumstances in California. In California, they say immediately for any, if it's a fatality, hospitalization, or whatever, it's immediately, and immediately under the Cal OSHA rule means as soon as practically possible, but not longer than 8 hours. You can, in certain circumstances, go beyond 8 hours if there are exigent circumstances, which is not defined, but generally means if there is some reason you are, still responding to the, involved in the emergency response, if this is out in some extremely rural area and you need additional time to report, but that's it. Outside of that, they're expecting these reports to be made as soon as possible and not longer than 8 hours. And we're seeing a lot of violations in California for employers who are following the 24-hour Fed OSHA rule. So that's it. We went way over today. I apologize for that. But I'm so glad you all could join us. I'd encourage you to check out our blog and to continue to join us for these webinars. We have a meeting, our OSHA practice here is meeting tomorrow to talk about the agenda for next year. So if you have ideas, please feel free to email us topics that you think we should be covering. But we're going to continue to do this. We love to spend this time with you all. It's been great for us to learn about all these topics, to present them to you, to get great feedback from you all, and to hear stories from you all. It makes this worthwhile. So there are a bunch of questions. I'll let those of you that need to check out because you've been with us and you're tired of our voice by now, feel free to do so. And I'll go through some of the questions that perhaps we haven't addressed yet. So let's see what we've got. And hopefully we've addressed a lot of these just through the discussion. There's good questions in here about understanding hospitalizations, really involving around, but they're not there 24 hours. If the employee is admitted, treated, but not at the hospital for 24 hours, that doesn't matter anymore. That used to be the test, that there was an overnight hospitalization, and that is relevant in California still. But for the Fed OSHA rule, if you're admitted and you receive medical treatment and that whole process lasts 5 minutes, doesn't matter, it's reportable. Once you're admitted to the inpatient service and you receive medical treatment, if that happens within 24 hours of the underlying incident, that's a reportable hospitalization. What else have we got? Yeah, there's a question here about medication, pain medication. Yes, that is considered medical treatment. Let's see. Oh, this is an interesting one. If an employee is admitted to the inpatient service for the purpose of a specific surgery, but they are not kept after the surgery, so it's sort of an outpatient surgery, but they are technically admitted to the inpatient service, if that admission occurs within the 24 hours, then absolutely, it triggers the concept that you've now been admitted to the inpatient service, and you've received medical treatment. If that happens within 24 hours, that's reportable. Well, you want to, this one about allergic reaction.
So we have a question that says an employee has an allergic reaction, they have an EpiPen, and they give him or herself a shot, and has to be treated by a paramedic and taken to the ER, would that be a reportable incident? So, I mean, I'll respond to this one. No, that would not be a reportable incident in and of itself. If the employee got to the hospital, was admitted to inpatient service, and then received further medical treatment, it might become reportable at that point, if that all occurs within 24 hours. But just, the employee having to give themselves a shot and maybe receiving some treatment on the way to the hospital would not actually create a reportable inpatient hospitalization.
Yeah, and sort of the broader analysis here is this work-related, right? I mean, and Lindsay covered this, I think, very well. If there is any condition in the workplace that contributed in any manner, even if it was, 3% the cause, it caused or contributed to the injury, that would be work-related. But if this is purely, you know, a personal exposure, I don't know. I mean, way you've looked at this, I know a lot more than I have.
You know, I think an allergic reaction in the workplace will often be work-related, because even though the allergy itself is a condition that may exist outside of, you know, the work environment and was not actually created by the work environment, the injury that results, the allergic reaction that might create like breathing issues or, you know, hives or something like that, that could be triggered by something in the work environment. And therefore, you know, the work environment would be a contributing factor or a cause of the particular allergic reaction.
It's a good question here about for an amputation, if a person gets a cut on their finger, days later it becomes infected, and then a medical amputation it takes place, I would say that's not reportable, right? The concept here is that the amputation must occur, the complete severing of the portion of the finger from the rest of the body must occur within 24 hours of the incident. So whether it's by natural circumstances or by medical amputation, if it occurs outside that 24-hour window, it would not be reportable. And likewise, even if it's not sort of an amputation scenario, if an infection occurs and you go to the hospital and you're admitted to the inpatient service and you're treated for that infection, but it's days later, not reportable because the hospitalization didn't occur within the 24 hours of the incident. Good question here. An employee is traveling for business. They're in the hotel room at night, you know, not actually performing work, and they pass away during evening hours while at the hotel. That, to me, the analysis is not really one of the reporting rule, it's one of work-relatedness. And I think you would have an awfully compelling argument to say that there's no reason to believe that that's work-related. You know, unless there is reason to believe it's work-related, right? Something happened while they were traveling. You know, they were visiting one of your chemical manufacturing sites and they were exposed to something, and then overnight they pass away. But you'd have, you know, a judgment call to make and some discretion in that analysis, but you'd have to have some reason to believe that it was work-related for that to become reportable. Oh, yeah, it's a really good question. Who's considered a supervisor regarding the trigger for reporting? I've not seen any specific guidance from OSHA on that in the reporting rule itself, but the general rule, and we see this most often in battles with OSHA about whether we get to participate in an interview during an OSHA inspection, and if it's a supervisor, you do, and if it's not a supervisor, there's a private interview is going to take place. The analysis for supervisor in the OSHA context, which I would assume is the same for the reporting rule, that's how I treat it anyway, is a much lower threshold than it is under most other labor laws and in most other labor circumstances. It's basically any person who supervises the work activities of another person. They don't need to have hiring and firing authority. They don't need to have discipline authority. They can be paid on an hourly basis. They can be identified as non-management for, you know, union purposes, for other classification purposes. But if if they give work assignments to others or they supervise the work that's being done by others, then they will be considered to be a supervisor in the OSH context, and therefore their knowledge about a reporting circumstance would be imputed to the company, and the clock would begin to run. So that's the way I've treated the distinction between supervisor and non-supervisor, even for the reporting rule. Yeah, there's a good question here about, you know, family members sort of interpreting that someone has been admitted, or whether they're admitted for hospitalization or treatment, can be a little tricky. And the idea is that, you know, somebody's spouse or, you know, parent or something like that is not a medical expert and maybe hasn't even looked at the medical files, and they don't, you know, may not know that there's a difference between, you know, the emergency status and inpatient status. So I don't put a whole lot of stock in what an emergency contact says to me. I try my best to get information from the medical provider, the clinic, the hospital, whatever it is. And if I just can't get it, if they refuse to share it with me, I may fall back on what I've learned from either the employee or from an employee's relative or significant other or emergency contact. But I'm going to make diligent efforts to get that information from the healthcare provider before I just rely on or accept what a family member says. So we got a few questions, and acknowledging that, hey, this is regarding another area of injury and illness record keeping. We are 2 weeks away from the December 1st deadline for submitting injury and illness data under the electronic record keeping rule. Folks asking if there's any update on that. There's no change to that. The one thing that's different since probably the last time we visited on a webinar is the first status report filed in the district court litigation that challenged the rule. That case was stayed, but as part of the stay, actually closed the case, but to be reopened if the parties deem it's necessary. But in the interim, every quarter the government needs to submit a status report about what's going on with the rule. The first one of those status reports was submitted either late September or early October, and it said, very interestingly, that OSHA is nearly finished with a notice of proposed rulemaking, that their economists are hard at work in an analysis of the rule, that they are basically pressing ahead as they have projected that they would in reopening the rule. They don't signal what changes we can expect, but it does seem like a given that they are going to publish a notice of proposed rulemaking in the Federal Register that will trigger a rulemaking that will involve some change or repeal of this rule. That's all very interesting and exciting, and the fact that economists are involved in it for OSHA tells me that it is going to be a significant change, because you don't need an economist analysis if it's going to be a minor change to the rule. So we'll see some major change to this rule, but it's not going to happen before December 1st. It is still conceivable that OSHA will announce a delay of that December 1st deadline, maybe even a substantial delay, to allow that rulemaking to start and finish before we first submit data, but I really, really doubt it at this point. So many people have already submitted data that if they were going to delay it, they would have done it already. So I think December 1st is going to happen. We're going to have to submit that data. So if you haven't already, get onto the website, get into the portal, get a feel for it, understand it, register the company and the establishments that will be reporting the data. But maybe wait another week, week and a half before you actually hit submit. But I'd start, if your mindset is that it's less likely to happen than it is to happen, switch that mindset and expect that we're going to be submitting data, and it looks like it's going to happen here on December 1st. Well, I think that's it so far. If we missed one of your questions or if we didn't answer it clearly enough for you, please do feel free to reach out to Lindsay or me. We love hearing from you. We love talking about these issues. I won't insult Lindsay, but I will say I'm a huge OSHA nerd, and I love talking about this stuff. So don't ever hesitate to reach out by phone or email, and let's talk about tricky OSHA issues that you're dealing with. And thank you all so much for sticking with us for so long today. And happy Thanksgiving, happy holidays, and we hope you join us for webinars in the future.
Yes, thank you everyone very much. I am not a huge nerd like Eric, but I am happy to answer questions, and I'm always available if you need anything, so definitely feel free to reach out.